So hello everyone, good evening and welcome to week 4. And tonight we will have a tutorial on the week 4 topic on foundation concepts of judicial review. And at this point, what we're going to do is to try to examine in greater detail some of the grounds for judicial review and try to draw a clearer distinction between legality and merits, which is the boundary between judicial review and merits review. And we will cover some of the key concepts as well, such as the grounds for judicial review, such as unreasonableness. And because that is a concept that was assessed in the topic, in the quiz for this week, which is quiz 3. As well, what we're going to do is to begin the tutorial by first going over the second quiz, mainly because I'm surprised that there were a number of students who actually failed to answer the quiz correctly. And it is important that we students be able to properly understand the issue about jurisdiction on the part of the Administrative Appeals Tribunal, as well as jurisdiction of the courts, because if the AAT, for example, does not have jurisdiction, then obviously you cannot have a merit review. And again, not all administrative decisions are actually subject to judicial review. So again, we need to determine when an applicant can potentially go to the courts for the purpose of seeking judicial review. And even when it might be said that a court can actually exercise judicial review, it is altogether a different thing to speak about whether there is an effective remedy. Because while it might be true that a court can actually examine an administrative decision, because you might be able to clearly show that an administrative decision was not done according to the law, but there are limits to what the courts can do in undertaking judicial review. For example, courts cannot step into the shoes of the original decision maker, nor can they remake the decision of the original decision maker. So even if it might be said that the decision of an administrative decision maker is contrary to the law, courts, and this is very crucial, courts cannot make a proper or a correct decision on behalf of the administrative decision maker. So if you were going to be a lawyer, or if you're answering one of our assessments for the midterms or the finals, you need to always ask yourself, assuming that the courts actually have jurisdiction to undertake judicial review, is there an effective judicial remedy? So that's the other key question we need to examine as well, because as we said, courts cannot remake the decision of the original decision maker, and neither can courts substitute their own decision for that of the original decision maker. So what can potentially happen is that the courts will say that the decision of the administrative decision maker is unlawful, but they will decline to correct the decision or come up with another decision that will be favorable to the applicant. Instead, what the courts will probably do is to quash the decision, which will mean that in a sense the decision is no longer effective. But it doesn't mean that, if a person were asking, for example, for certain benefits on the basis of the law, and the courts, for example, will say that there was an error of law when the administrative decision maker arrived at the decision, still, you cannot ask the courts to compel the original decision maker to grant you the benefits which might be available under the law, simply because the courts cannot substitute its own decision for that of the original decision maker. So these are foundational concepts which we need to examine, because there is a limit to the power of judicial review. Now, merits review is, of course, the better recourse, because as we said, when we speak of merits review, hello Tim, thanks for joining us. The advantage of merits review is that the merits tribunals, for example, actually step in the shoes of the original decision maker, which means they exercise the powers of the original decision maker, and therefore they are in a position to actually remake the decision of the decision maker, vary it, or even substitute their own decision for that of the original decision maker, because that is the power of merits review. Because essentially, when you speak of merits review and the exercise of the powers of the administrative tribunal, what is actually happening is that what we need to remember is that the administrative tribunal is part of the executive. So it's the administrative tribunal, therefore, is a crucial tool by which the executive is able to correct any mistakes of its own. Now, when you look at the courts belong to a different body in the government, and courts do not exist to be over and above the executive. So you will know, for example, as we see in one of the discussion questions today, that courts will not interfere with political decisions made by the executive, because courts cannot claim to be over and above the executive. As we know, it is actually the Prime Minister and the Cabinet that actually ultimately wield the power in government, because they are the elected representatives of the people. So having said that, tonight, after studying this topic, you should be able to discuss and explain the concept of legality in judicial review, when an administrative decision is unlawful or contrary to law, and the grounds for judicial review of administrative decisions under common law and under the Administrative Decisions Judicial Review Act of 1977 Commonwealth. Now, before we talk about this week's topic, what I'd like to do is to just briefly touch upon quiz number 2, because, as I said, if you fail to properly understand the jurisdiction of the Administrative Appeals Tribunal or the jurisdiction of the courts undertaking judicial review, you got to get it wrong. Okay, can I ask somebody to read quiz number 2 question? So this has already been answered. We just want to go through. I just want to provide some further clarification of the concepts, because a lot of the students did not get this question correctly. And that surprises me, because this is adequately covered in the study guide, in my lecture podcasts, as well in the tutorial last week. Can I get somebody to read the question?
Yeah. Hello? Hello, can you hear me?
Clinton?
No. Yeah, can you hear me? Hello?
Okay. Am I going to
Can you hear me, yeah?
Okay.
Oh, no, I'm keen.
So I'm going to just go through the question. Feel free, if you want to jump in, feel free to do so. So this is the quiz. And as I said, my purpose is just to clarify some points. So the Australian Minister for Immigration and Border Protection, or the Minister, terminated the employment of visa officer Josh Goodwin. Oh, is Clinton speaking now? No, I couldn't hear Clinton. Hang on. Is there something wrong?
Yeah, hello? Can you
I
hear
can hear
me?
you now. Okay, very good. I can hear you, Clinton. Go ahead.
Yeah, sweet.
Thank
All
you.
right. The Australian Minister for Immigration and Border Protection, the Minister, terminated the employment of visa officer Josh Goodwin after the latter was found, after an internal disciplinary hearing, to have committed a gross error both in law and in fact, in applying the Migration Act 1958 to the application for an Australian permanent residence visa of Omar Usari. Usari had committed domestic terrorism in Australia. The Minister used his statutory executive power in terminating the employment of Goodwin. Goodwin has approached you, a solicitor, for legal advice. He wants to apply for a review of the administration decision terminating his employment. Which answer is the most correct?
Okay, thank you so much, Clinton. So let us emphasize here that the minister had used his non-statutory executive power in terminating the employment of Goodwin. Okay, now, while the decision which the minister had reviewed had related to the Migration Act, but the power which was exercised by the minister for the purpose of terminating the employment of Goodwin was, under the facts, a non-statutory executive power. So in other words, the minister was exercising, the inherent powers of the executive, which we said exists on the basis of the prerogative power. So even in the absence of a constitution, for example, we know, like in the UK or New Zealand, we know that the executive exists and it does have power, even in the absence of a constitution, because there can be no government that exists without the executive. So the courts recognize that there is an inherent power in the executive to govern and to execute the laws. So we're clarifying here that the minister had used non-statutory executive power. So if we look at the potential answers here, perhaps I can ask Clinton to go through the answers as well. The possible answers, Clinton?
Yeah. Which answer is the most correct? He cannot apply for a merit review with the Administration Appeals Tribunal, AAT, because the decision of the minister was based on the executive of non-statutory executive power, the exercise of non-statutory. He cannot apply for a merit review with the Administration Appeals Tribunal, AAT, because the AAT has no jurisdiction to examine legal errors in the administration decision. You've got C. He can apply for a judicial review under the Administration Decisions, Judicial Review Act 1977, because the termination was made by the minister on the basis of the exercise of non-statutory executive power. And then D, you've got, he can apply for a merit review with an Administration's Appeals Tribunal because the decision of the minister was based on enactment. And then all answers are wrong.
Okay, so I'm just going to jump, unless somebody wants to provide an answer. Did somebody get the answer correctly? So as we know, the correct answer is this one. The correct answer is he cannot apply for a merit review with the AAT because the decision of the minister was based on the exercise of non-statutory executive power. Now, let me just clarify a key point there. Even assuming, so we know that that is the correct answer because the facts already said that the minister exercised his non-statutory executive power. So that's the correct answer there. But let me just clarify a point. Because even assuming that the minister exercised a statutory executive power, that alone is insufficient to vest jurisdiction with the Administrative Appeals Tribunal to undertake merits review. That alone is insufficient, okay? As far as the jurisdiction of the AAT is concerned, there are at least two things that are required. One is that the minister should have made a decision on the basis of an enactment or a statute, but at the same time, that particular statute must also provide that recourse can be had with the Administrative Appeals Tribunal for the purpose of a merit review. So in other words, the function of the enactment would be two. One is that the source of the power of the executive in making a decision is the enactment, but at the same time, that particular enactment must provide that an applicant can seek a review of the decision with the Administrative Appeals Tribunal. So those are two critical requirements for there to be jurisdiction on the part of the AAT, of course, apart from the question of legal standing. Now, if we contrast the jurisdiction of the AAT with that of the courts under the Administrative Decisions Judicial Review Act of 1977 Commonwealth, there's some similarity because if the decision of the executive was based on the exercise of a non-statutory executive power, then there can be no jurisdiction on the part of the courts under the ADJR Act of 1977, okay? So once a decision is based on the exercise of a non-statutory executive power, the courts cannot have the power of judicial review under the ADJR Act. But if an administrative decision was made under an enactment, that alone will be sufficient to vest jurisdiction with the courts to undertake judicial review under the Administrative Decisions Judicial Review Act. Okay, so to sum it up, if a decision is made by an executive on the basis of an enactment, then you can seek judicial review with the courts under the Administrative Judicial Review Act of 1977. Okay, so if a decision is based on an enactment, you can have recourse to the courts for judicial review under the Administrative Decisions Judicial Review Act of 1970 Commonwealth. However, if a decision is made on the basis of an enactment, that alone is insufficient to vest jurisdiction with the AAT for merits review, because there are two requirements for the AAT to have jurisdiction. One is that the decision was made on the basis of an enactment. And secondly, that particular enactment itself must also provide that an applicant can seek a review of the administrative decision with the Administrative Appeals Tribunal. So what it essentially means is that the Administrative Appeals Tribunal Act of 1975 Commonwealth, which created the AAT, did not vest in the AAT the power to undertake merits review. The power to undertake merits review is actually provided by other enactments or statutes which vested with the AAT the power of merits review. On the other hand, if you speak about the Administrative Decisions Judicial Review Act of 1977 Commonwealth, it is that particular statute, the ADGR Act 1977 Commonwealth itself, which vested in the courts the power of judicial review. Was that clear? So I hope that's clear, because that's really a critical point there. Now let's go to the current quiz. We're not going to answer this quiz, but what I intend to do is just to highlight some key points. And of course, at the end of this session, you should really be in a position to answer this quiz, because we're going to cover some of the key points here. We're not going to directly answer that question because, you know, I can't do that. This is part of the assessment. But by listening to the tutorial, there's no reason why you will, you know, get it wrong in answering this quiz. So can I just get a volunteer to read quiz number 3 for us, please?
Yeah, I can.
Thank you, Millie.
The Australian Federal Police 1979 Commonwealth, the Act, provides for the qualifications that individuals must possess in order to be employed in the Australian Federal Police. It also provides that the AFP Commissioner has the absolute discretion to impose other employment qualifications as he or she thinks fit. Kareem Lankawi, a devout Muslim and naturalised Australian citizen, applied for employment in the AFP in response to a job advertisement in its website. A month after his application, he received a letter informing him that his application had been declined because he failed to meet certain security requirements associated with being a Muslim that were imposed by the AFP Commissioner in the exercise of his absolute discretion to impose other employment qualifications as he or she thinks fit under the Act. Lankawi has approached you, a solicitor, for legal advice. Do not read the AFP Act.
Very good. Thank you. Can you read the potential answers there as well, Millie?
Yeah. So which of the following statements is most correct? A, where an administrative decision maker exercises discretion in the making of a decision under an enactment, such a decision can only be subject of merits review by the AAT, assuming the AAT has jurisdiction, and not judicial review, since there is no legal question that is involved in that instance. B, judicial review is available to determine if a discretionary power conferred by statute on an administrative decision maker has been exercised reasonably. C, judicial review is not available in this instance because employment decisions by the AFP involves a political question and is non-justiciable.
Justiciable, yes.
Justiciable. Next one, when a statute confers absolute discretion on an administrative decision maker, the exercise of such an absolute discretion is beyond the scope of judicial review. And the last one, all of the answers are wrong.
Okay, very good. Thank you, Millie. So let's just go back quickly to the quiz. Okay, so what we note here, and this is the tricky part, it says that the AFP Commissioner, so the AFP Commissioner is exercising his powers on the basis of an enactment, the Australian Federal Police 1979 Commonwealth Act. Okay, so that's the basis, 1979 Act 1979. So that's the basis of the exercise of the power by the Australian Federal Police Commissioner. Okay, so it's based on an enactment. So that's clear. The question, however, is that power there, where it said that the commissioner in the exercise of his absolute discretion, can you imagine that, absolute, to impose other employment qualifications as he or she thinks fit. Okay, because it's absolute, does it mean that, you know, it can only be if there were a review of an administrative decision, it can only be with the AET on the basis of a merits review, or can there be judicial review if a discretion has been exercised? And here, not only is the discretion exercised, the discretion is even absolute. So that is the question there. Because we recall when we discussed the topic last week, we did say that when it comes to judicial review, the scope of judicial review is to examine the legality or lawfulness of an administrative decision. So it's about whether or not a decision is according to the law or contrary to the law. Merits review, however, is broader, obviously, because it talks about whether a decision is the correct or preferable one. So when you speak, for example, of the correct decision, it is correct according to the facts, it is correct according to the law, or it's correct according to policy. And so because we're speaking of correctness, we know in terms of the merits review that there should only be one correct decision, okay, according to the facts, the law, or the public policy or the policy of an organization. When we speak, however, about a preferable decision, that means that's a question of the exercise of discretion. In other words, when somebody exercises discretion, the decision maker can do this, the decision maker can do that. For example, the decision maker can say that I choose to give this particular benefit to this person, the amount of maybe $1,000, or I will decide based on the exercise of my discretion not to grant it, or maybe I'll grant $5,000. But because it involves discretion, what it means is that the decision maker has a huge latitude and scope to exercise that power because it involves discretion. So it's very clear that when it comes to merits review examines not just the correctness of a decision, but also whether or not the decision is preferable according to the exercise of the discretion. Now, judicial review does not really look at the exercise of discretion, because judicial review is all about looking at the whether or not the decision is lawful or contrary to law. But how about if a discretion has been exercised unreasonably? So let's say that, and we're gonna see an example here. What if, and I'm just gonna move it a bit, okay? So for example, what if the AFP commissioner decided not to hire somebody, Karim, because Karim looks ugly to him, or Karim is bald, or Karim has a mole, on his forehead. You know what I mean? So what if the decision maker makes those decisions? He says, "Oh, but I have absolute discretion, and so exercising my discretion, I will not hire Karim because Karim is, as I said, as an example, he's bald, or he has a mole on his forehead, or his hair is weird. It's kinky, or his hair is orange in color, and I don't like, how do you call that in Australia? The rat, orangey or rango or something. I heard one of my sons saying it. So the question is there a requirement that even if a discretion is exercised and there is an absolute discretion, is there a requirement of it having to be reasonable according to the law? So that if the exercise of discretion is unreasonable, then that decision becomes unlawful and therefore subject to judicial review. So that is exactly what I'm hoping for you to think about. And we're going to have a chance to touch upon that, okay, in the course of these tutorials. So can I just ask you briefly, it's going to be quick, try to attempt to provide an answer to these, to the question, to the quiz. On the chat box, can you give me an answer, whether it's A, B, C, D, or E, which, based on the facts. So remember, Karim was not hired because he was associated with being a Muslim. So he was being a Muslim. So remember here in the example, the AFP commissioner did not hire Karim because he was a Muslim, okay? And remember, the AFP commissioner was exercising his power, his absolute discretion to impose other employment qualifications as he or she thinks fit. So can I just ask you to type an answer in the chat box? This is, this is just a practice quiz. You don't have to be marked for this, but at least it will help you remember what is the proper answer here. What do you think is the correct answer to the quiz? Is it A, B, C, D, or E? Can I give you a minute to do that? Just type an answer there in the chat box. Okay, so I'm still waiting for the answer from two more. Okay, very good. So, very good. So I think the class is getting the answer correctly there. Well, I didn't say which was the correct answer, but at least I'm seeing the correct answer. Very good. We're going to go back to that, but I'm glad that you're picking up the hints I was giving. Very good. Okay, so we're going to go back to this quiz because we're going to touch upon the question about discretion in problem 3. But we're going to go through 2 other questions first before we revisit the quiz. And so please be mindful about this quiz because it talks about the grounds for judicial review. Okay, let's just talk about discussion question 1, and then we're going to revisit the quiz in discussion question number 3. So thanks, everyone, for providing an answer. Okay, can I get somebody to volunteer to answer this discussion question 1 for us?
Yeah, I'll do it.
Thank you, Tim. Thank you.
Sheldon Wang applied for the family tax benefit with the Department of Human Resources on the 15th of March 2015, the day after he was granted an Australian permanent residence visa. A new tax system, Family Assistance Act 1999 Commonwealth, provides that an Australian permanent resident who has an FTB child, who Wang has, is entitled to the FTB. However, under the new regulations passed by the Minister for Human Resources, an Australian permanent resident excuse me, is eligible for the FTB only if he or she has held that permanent resident status for at least 1 year. On account of the Minister's new regulations, the application of Wang for the FTB was denied. Wang's repeated request to the Minister's delegate to reconsider the DHS decision was denied. Wang has approached you as a solicitor for legal advice. He is thinking of asking the courts to review the administrative decision. In particular, he would like the court to set aside the DHS administrative decision and order the DHS to grant him the FTB. Is the court likely to grant the remedies sought by Wang?
Thank you, Tim. Very good. So the crucial point really of this quiz is whether or not only can the court set aside the DHS administrative decision, but whether or not a court can order the DHS to grant him the FTB. That is the crucial legal issue there. Can the court, undertaking judicial review, order a decision maker to grant a particular benefit? So in other words, can the court substitute its own decision for that of the original administrative decision maker? That is the legal issue. So is the court likely to grant the remedy sought by Wang? Can I get an answer from everyone? So from Rebecca, no. Is the court likely to grant the remedy sought by Wang? No. Very good. No from Rebecca, no from Tim, no from Millie, no from Harry. Are we missing somebody? Clinton. Okay, very good. Fantastic. The answer is no. Well done. So, and we will see that and I think we're going to revisit this in discussion question 2, what we will notice is that what the minister had done was to add a requirement which was not under the statute. He imposed another requirement that the FTB can only be granted by somebody who has held permanent resident status for at least a year. And we're going to examine this, whether or not, assuming there is a law and an administrative decision maker imposes another requirement which is not authorized by the law or by the primary legislation, would that further requirement by the decision maker, is that lawful or not? Okay, we're going to examine that in discussion question 2. But meanwhile, let's assume that it was unlawful for the Minister for Human Services, let's assume for the moment that the Minister for Human Services it was unlawful for the minister to have imposed another requirement. Let's assume that it was unlawful. Can the court order the DHS to grant Weng the FTB? And as everybody said, the answer is no. Fantastic. Why? Why not? Why not? Very good from Tim. The court could only set aside the decision. That's a key point there. So can you see what happens now? Assuming that the decision by the minister is unlawful, meaning it is contrary to law, the court can set aside the decision, but it cannot order the minister to grant the benefit. So to an extent, it's almost an empty victory. Yes, you got it right. The court struck down the decision, but still, you didn't get the benefit. And that is the case of Green versus Daniels. So the court will agree with you. Yes, you're correct. The minister made the wrong decision, but we don't have the power to grant you the remedy. So that's a key limitation of judicial review. Now, it doesn't always happen that just because courts cannot vary a decision, or it cannot substitute the decision of the decision maker, or it cannot remake a decision of the decision maker, it doesn't mean that the power of the courts therefore would be ineffective. For example, taking it from the viewpoint of immigration, assuming that the minister it's not the Department of how do you call it now? It's no longer the Minister of Immigration. It's the Department of, what's the new name for the powerful department under Peter Dutton? Home Affairs, I think. Okay, so let's assume that the Minister for Home Affairs decides to deport a New Zealand citizen who is a permanent resident in Australia on the ground that that New Zealand citizen has previously been in prison for a year, and under the Migration Act of 1967, therefore he is an undesirable alien, or he's an undesirable person, and subject to the exercise of the power of the minister, can be deported from Australia. Now, if that particular person applied for judicial review, the effect of the quashal of the decision of the minister would be for that decision to deport that New Zealand citizen to be set aside and to be quashed, which means he can no longer be deported. So there is a legal effect. By quashing that decision, that person can no longer be deported. But it is altogether a different thing to compel a decision maker to act in a particular way, because courts do not have that power. They can only set aside a decision or quash the decision, but they cannot vary a decision. But quashal can be important. For example, what happens if the Australian Tax Office decides to issue a garnishment order against, let's say you have a client, and the client perhaps has been assessed to have had tax arrears, let's say amounting to $100,000. And so because your client has failed to pay for the tax arrears at some point, the Australian Taxation Office decided to issue a garnishment order against the funds of that client. Now, if you were to go to the courts and sought judicial review, the effect of a quashal of that decision would be that there is no garnishment order. So there is a legal effect, because in that case, the funds of the client can no longer be garnished because the courts would set aside that particular order. There is an effect. But what if in the example I gave, you're also asking the court to order the ATO not to investigate further or not to, do further things in relation to your client. Or in particular, if you were to order the ATO, for example, to maybe return some amount of money which had previously been garnished. In that particular case, it can't be done because the power of the court is limited to setting aside a decision, but it cannot order a decision maker to act in a particular way. And certainly, the courts cannot exercise a discretion which lies with the original decision maker. So we're clear. Very good. So here, a court is unlikely to grant the remedy sought by Wang, the remedy which was for the minister to grant the FTB, even assuming that the decision of the minister was unlawful, meaning it's contrary to the law. Courts are powerless to grant that remedy of providing the FTB, because courts can only set aside a decision or quash a decision, but it cannot vary a decision, nor can it substitute its own decision for that of the decision maker. Okay, very good. Well done. You all got it right. Very good. Discussion question 2. Can I get a volunteer to go through question 2 for us? Just to read the question. Can I ask somebody to do it?
Oh, I will try. Hello?
Clinton, thank you. Yes, go ahead, Clinton.
Yep. Sheldon Wang applied for the family tax benefit with the Department of Human Services on the 15th of March 2015, a day after he was granted an Australian permanent residence visa. The ANU Tax System Act 1999 provided that an Australian permanent resident who has an FTB child, who Wang has, is entitled to the FTB. However, under the new regulations passed by the Minister for Human Services, an Australian permanent resident is eligible for the FTB only if she or he has held that permanent resident status for at least 1 year. On account of the Minister's new regulations, the application of Wang for the FTB was denied. Wang's repeated request to the Minister's delegate to reconsider the DHS's decision was denied. Wang has approached you as a solicitor for legal advice. What legal steps would you suggest and why?
Thank you. Now, for the moment, because we're looking at judicial review, let's just not look at it from the viewpoint of merits review, okay? Because as we said, if that particular law, for example, provides that merits review can be available, then of course your legal advice should be that go to the AAT. But let's assume for the moment that we're just looking at the question of whether or not you should advise Wang to apply for judicial review. Okay, so the question is, what would you do? Would you advise Wang to apply for judicial review? That is the question. So that's a broader question. The first one was in the first example we had. The question was whether or not Wang should apply for judicial review in order to get to ask the court to compel the minister to grant the benefit. That was the legal issue there. Here, the legal issue simply is, what legal advice would you suggest? Meaning, is there scope for judicial review? Would the court, have jurisdiction to undertake judicial review? And if judicial review were undertaken, what legal effect would it have? Because we already know the court cannot order the minister to grant the benefit that Wang might seek. So what advice would you give to Wang in relation to whether or not Wang is a guide. So in relation to whether or not Wang should apply for judicial review, particularly under the Administrative Decisions Judicial Review Act of 1977 Commonwealth. What do you think? Would you advise Wang to apply for judicial review or not? So it's a yes or no. What would you do? Can I just see some answers there? So we've got an answer from Tim. No. What do the others think? No. Okay. But from Rebecca, Clinton, and Harry. From Clinton, M to victory. Okay, go on. Millie, no. Interesting. Okay. Has everybody answered? Okay, Harry, no. Okay, good. Now, let's think about that. So there's a suggestion that it is an empty victory. Let's settle the first question. Would the court have jurisdiction to undertake judicial review? Can we just settle that first question? Would the court have jurisdiction to undertake judicial review? Okay, can I get a yes or a no? Would the courts have jurisdiction to undertake judicial review? Very good. Okay, now, so we know that the court can undertake judicial review because it seems that the decision is based on enactment. But the question is, was the decision contrary to law? Why would it be contrary to law if the minister imposed another requirement? And the answer is that the decision of the minister would have been contrary to law, because what has happened is that this is known as a subordinate legislation, which was passed or drafted or crafted by the minister. And because it is a subordinate legislation, the subordinate legislation must comply with the primary legislation. The primary legislation is that the law that was passed by the Commonwealth Parliament. So if the Commonwealth Parliament did not provide for that requirement that somebody must have been a permanent resident for at least 1 year, then the minister does not have the power to impose that new requirement, because that would be contrary to the primary legislation. So there is a ground for a judicial review of the decision, because it would be contrary to the Act, unless the Act, as pointed out by Tim, allowed the minister to. But under the facts, we assume that the minister is not empowered by the law or by the enactment to impose that additional requirement. We assume for the moment that the law does not allow that. So therefore, the minister's regulations are contrary to law. Okay, so we have that. But the question is, so if there is jurisdiction on the part of the courts to undertake judicial review because the decision is based on an enactment, and there is a ground for judicial review because the decision was unlawful, because the minister had exceeded his powers under the statute, so you have a ground. The question is, would you therefore suggest that there be a judicial review? Now, I would give a different answer to that which the members of the class said. So the members of the class had essentially said, at least those who are in the tutorial tonight, had said that we shouldn't apply for judicial review because it is an empty victory. The answer is, my answer would be that no, there is a benefit to seeking judicial review, because firstly, the courts we know has the power of judicial review. Would it be an empty victory? The answer is no, because if you look at the Administrative Decisions Judicial Review Act of 1977 Commonwealth, the courts actually under that particular act have the power to make a declaration that the minister's decision is contrary to law. Okay, let me be clear. So the Administrative Decisions Judicial Review Act is a very important piece of legislation, because in a sense it codifies the grounds for the judicial review, which exist also in the common law. So in other words, decisions of the courts saying that, what can be the grounds for the judicial review are now incorporated in the Administrative Decisions Judicial Review Act of 1977. So it's a very important piece of legislation. Instead of having to look for grounds for judicial review, the ADJR Act itself provides for various grounds for judicial review. But at the same time, the ADJR Act actually also, in a sense, codifies the powers of judicial review. Now, we will recall that under the common law, we have the power of injunction, the power of declaration, or the power of mandamus. These are common law judicial review grounds. However, the grounds for these judicial review remedies to be granted with the courts are actually quite limited and narrow. The advantage then of the Administrative Decisions Judicial Review Act of 1977 is that once there is a ground for judicial review and the court has jurisdiction to undertake judicial review, it can exercise various powers under that particular act. And one of those powers is actually to make a declaration that a decision by an administrative decision maker is contrary to law. So If therefore you apply for judicial review, because we know that the court has jurisdiction because the decision was based on an enactment, and we know that there is a ground for judicial review because the decision was contrary to law, meaning contrary to the enactment passed by the Commonwealth Parliament, that remedy by the court, which is to issue a declaration that the minister's decision was contrary to law, is important, because it tells the minister that he cannot impose this additional requirement. So while the effect would be to quash the minister's decision, and what would then happen would be for the decision to be remitted back to the minister, when he tries to review his decision, will most likely therefore make a decision according to what the court has said is actually what the law should be. And so if the court says that the minister has no power to impose another requirement, then the minister will be required to be compliant with the interpretation of the courts of what the law will be. And for that reason, the minister is likely to drop that requirement of a person needing to be a permanent resident for at least 1 year. So while there is no direct benefit to Wang, in the sense that Wang does not get the benefits straight away, but because of the court's decision, quashing the minister's decision and making a declaration that the minister's decision is contrary to law, the minister will now be required, according to the rule of law or the requirements of constitutionalism, to abide by the proper legal interpretation according to the courts, which means the minister will now be legally required to remove that requirement of an applicant needing to be a permanent resident for at least 1 year. Can we see the distinction there? So in the discussion question 1, the question was quite clear. Can the court compel the minister to grant the benefit? The answer is no, because courts cannot vary a decision, nor can it compel the decision maker to act in a particular way, nor can the court substitute their own decision. This question, however, is different, because the question is, would you suggest, for example, that Wang apply for judicial review? So it's broader, and the answer is yes, because the courts have jurisdiction, but at the same time, when a court quashes the decision, and when the court makes a declaration that the minister's decision was contrary to law, particularly that the minister's decision imposing a new requirement is contrary to law, then the minister will be required to change his decision, change his regulation, which would then benefit Wang. So while the court is not itself remaking the decision, it provides the minister the opportunity to remake his own decision according to the legal interpretation made by the courts. Was that clear? Questions, comments? We're clear. Very good. Okay. So discussion question 3, and discussion question 3, please take note that as we go through this question, we're trying to draw some concepts here in relation to the quiz number 3, because we talked about the exercise of absolute discretion. So remember, the question I had to you was, if a decision maker assuming that a law, so this is I'm just going to summarize a factual scenario here, which is related to question 1 in relation to the quiz this week, and relevant to discussion question 3. So in sum, let's assume a factual scenario where a statute provides that a decision maker has an absolute discretion to make a decision according to whatever he deems fit, absolute discretion. And let's assume that, for example, that involves the power to hire somebody or not, okay? And because of the absolute discretion, the decision maker said, I'm not going to hire that person because I don't like his hairstyle. I don't like the way he dresses. I don't like his shoes. I don't like the way he smells. I don't like the mole on his forehead. And remember, the law is, the provision is, the decision maker's absolute discretion to hire somebody or not, according to however he deems it fit. So the question is that because it's absolute discretion, will the courts actually have the power of judicial review? Or is there a requirement of reasonableness? So that was my broad question, okay? So discussion question 3. Can I ask somebody to read question 3 for us? Can I get a volunteer?
Yeah, I'll have a go.
Thank you.
The Australian Federal Police AFP 1979 Commonwealth Act, the Act provides for the qualifications that individuals must possess in order to be employed in the Australian Federal Police. It also provides that the AFP Commissioner has the absolute discretion to impose other employment qualifications as he or she thinks fit. Pursuant to the Act, the AFP Commissioner issued regulations that required applicants for employment in the AFP to pass certain security requirements, including background checks on their ethnicity, religion, and social, ethnic, cultural, and family associations. The regulations also stated that the AFP Commissioner or his delegate had the discretion to waive the security requirements for employment applicants, including background checks on their ethnicity, religion, and social, ethnic, cultural, and family associations. Boris Kasanov, a Bosnian Serb immigrant and naturalised Australian citizen, applied for employment with the AFP in response to a job advertisement in its website. A month after his application, he received a letter informing him that his application had been declined because he failed to meet certain security requirements related to his association with a paramilitary group in Bosnia in the 1990s. Kazanov has approached you, a solicitor, for legal advice. He wants to know the likelihood of a federal court acting favourably on his application for judicial review of the decision of the AFP Commissioner, particularly relating to the failure of the AFP Commissioner or his delegate to waive the security requirements for employment applicants, including background checks on their ethnicity, religion, and social, ethnic, cultural, and family associations. What advice would you give him?
Thank you, Tim. So can I just highlight a few points? Again, the key provision there under the law is that the AFP Commissioner has the absolute discretion to impose other employment qualifications as he or she thinks fit. Okay, so same provision there, I think. Now, at the same time, what we need to know is that the AFP Commissioner declined the application because Kasanov failed to meet security requirements related to his association with a paramilitary group in Bosnia in the 1990s. Let me highlight a fact here, okay, based on the question. It is very broad, okay? What if the association of Kasanov to the paramilitary group? So if you will recall, in the late 1990s, some of you I think might be too young, but there was an ethnic cleansing which happened in Bosnia and Serbia in the late 1990s. Hundreds of thousands of Bosnians were killed by the Serbs, and you've got Karadzic, was eventually accused of war crimes and was eventually indicted and convicted by a war crimes tribunal in The Hague. Okay, so it was a very bad time. We would have thought that ethnic cleansing would no longer happen, but it did happen. And people are dropping out now. And so here, the point here is that there is an association with a paramilitary group. What if Kasanov's association is merely that one of the members of the paramilitary group happens to be his friend, okay, or happens to be his brother, or happens to be his uncle, but he himself is not part of the paramilitary group. So let's just make that assumption here. Let's assume that Kasanov is not in fact part of the paramilitary group, but his uncle is a member of the paramilitary group, and because of that association, that his uncle is a member of the paramilitary group, although he is not, would that be sufficient for the AFP Commissioner to then decline to hire Kasanov because the AFP Commissioner says he has the absolute discretion to impose whatever employment qualifications as he or she thinks fit? Okay, Millie also has to go. A lot of people seem to be dropping out. So let me just go. Would you like me to just provide the answer now before you go? So before Millie goes, the answer here is when it comes to the question of whether or not simply because somebody has absolute discretion, that person can do anything he likes, The answer is no, because it will still be subject to the question of reasonableness or unreasonableness. So whilst it may be true that, oh, Millie's gone. Okay, so she didn't get the answer. So while it is true that a law may provide, a decision maker with broad powers of absolute discretion, the exercise of that absolute discretion must still be reasonable. So where there is an unreasonable exercise of discretion, that will be contrary to law. Okay, so even if the AFP commissioner has absolute discretion to impose other employment requirements, the AFP commissioner cannot say that a person must not be bald, that a person must not belong to an ethnic group such as, he cannot be Japanese, he cannot be Indian, just because he has absolute discretion. Or the minister cannot say that a person cannot be hired if a person has a mole on the forehead, or a person has previously sought an examination by a GP for depression. Even if there is absolute discretion, that absolute discretion must be exercised reasonably, because an unreasonable exercise of discretion will be contrary to law, both on the basis of common law, which as we will see, I think in week 7, what is known as Wensbury reasonableness, or if you look at section 5(2)(f) and G of the ADGR Act, it talks about the exercise of a power needing it to be reasonable. So section 5(2)(g) of the ADGR Act, for example, says that the exercise of a power must be reasonable, because if it is so unreasonable that no reasonable person could have so exercised the power, that will be contrary to law. Okay? Okay. Questions? Was everything clear, or was that too fast? Hopefully not. Can I get some comments or feedback? Questions, comments, before we end tonight's session?
Yeah, hello, sir.
Sorry, Clinton?
Hello?
Yes, Clinton.
Just that last one.
Yeah.
Yeah, just the last one. The unreasonableness in, you've got it in the Judiciary Act.
Mm-hmm.
Is it the unreasonableness in common law? Is that right? Like when we start to put down references for that unreasonableness.
Okay.
What you reference the common law for the unreasonableness, which is the Wensbury case.
Very good. Very
good. And what's the other one? For
the statutory basis, meaning either the Administrative Decisions Judicial Review Act of 1977 Commonwealth or the Judiciary Act of 1903 Commonwealth.
1903. Yeah. All right. Sure.
So that it was the Judiciary Act of 1903. So very, very good point, Clinton. So if you can, it will be best if you're providing an answer or advising a client later on. It will always be best that if you are going to seek judicial review or apply for judicial review, if you can base it on the Administrative Decisions Judicial Review Act of 1977 Commonwealth, that is preferable, because as we said, that particular statute is a codification of the grounds for judicial review, as well as the remedies available for judicial review. So that's the advantage there. The problem, however, with the ADGR Act, as we said, is that it doesn't cover all forms of administrative decision making. It is a requirement for there to be jurisdiction of the courts under the ADGR Act that the decision must have been based under an enactment. So if a decision was not based on an enactment, such as the minister, for example, a minister for immigration, for example, exercising his inherent non-statutory executive power, let's say to deport somebody, or let's say not to allow the boat refugees to enter into Australia. So you can't go to the ADGR Act because that decision, as we said, is non-statutory. In which case, you can examine the common law. So if you can argue that the exercise of a minister's decision was unreasonable because no reasonable authority or no reasonable agency could arrive at a decision, so therefore that's Wensbury unreasonableness, then you can seek a common law judicial review before the courts, even if the decision was not based on an enactment. So that's a crucial point there. Now, however, let's be clear. We will later on see that this idea of Wednesbury and reasonableness is actually of a very high standard, because you cannot just say that the decision is unreasonable. It has to be Wednesbury and reasonable. And as we later on see, when you speak of Wednesbury and reasonableness, it must be so unreasonable that no reasonable person could have so exercised the power, which is actually a very high standard. So, but the example I gave was, in the particular example I have here, you cannot, it would be unreasonable for the minister to decline to accept somebody simply because that, somebody who belongs to a paramilitary group happens to be the uncle of a person. What has that got to do with anything? Or happens to be a distant relative or a friend. Okay, that would be unreasonable. You can't just, your standing can't just be tainted simply because you know someone. Wouldn't you agree? Or simply because you happen to have, had a few drinks with this person, does it mean you're now associated? So that would be unreasonable. But otherwise, as we later on see, the question of Wednesbury and unreasonableness is actually of a high standard. But in the example here, it is very unreasonable. It is Wednesbury and reasonableness, because the example you gave was, he was simply associated with a paramilitary group because his uncle was a member of that group. He himself was not a member, but just his uncle. That is an example of Wednesbury and reasonableness. Okay, so hopefully you have the answer tonight. So the basic legal issue was, does it mean that simply because a decision maker was granted by a statute the absolute discretion to act in any way he wants, does it mean therefore that courts no longer have power of judicial review? That was just the legal issue there. And you should have the answer by now, right? So the legal issue is, does it mean that because a law has given a decision maker an absolute discretion to exercise his discretion or power in any way he likes, does it mean that the exercise of the discretion is now beyond the power of judicial review? I think we know that answer already. Okay, and a lot of you got the answer right when I first asked the question. So before we end tonight's question, are there any questions or comments? We're good. Okay, so thank you, Clinton, Rebecca, Harry, and Tim for joining tonight's session, and Millie as well, but she's gone. And please be reminded that for our tutorial for next week, we will do it on Monday, not on Thursday. It's just going to happen during the term, it's going to happen only once. I won't be available on Thursday or next week, so we're going to have the tutorial on Monday at 6 to 7 p.m. Okay, so thanks everyone, and I hope to see you again on Monday next week. And enjoy your weekend. Thank you. Bye.